15 of the JJ Act talks about presumption. It can be through visual appearance, it can be through interactions with the offender, with the or the child or the person who has suffered the offence with the JJ board. But it is actually section 94 of the JJ Act which lists these three, I think section 94 1 or 2, but it has these three ways of determining age. Number 1 is school certificates. Number 2 is certificates from the corporation, municipal corporation. And number 3 is the ossification test. And when I was doing a little bit of reading actually last night, I came across these this one technique which is being used now by the US immigration authorities. You know that there is huge thing going on under the president of the United States policies that immigrants should be sent back, etc. They've come across this test called the wisdom teeth test, and that wisdom teeth test is the third molar tooth, which usually sprouts between 17 and 25 years of age. And they feel that the margin of error in the wisdom teeth test is much lower than the bone ossification test. The second, the recent technique which I came across is called the epigenetic clock. The epigenetic clock test. That actually measures the age using the age of DNA and the age of, the methyl conditions of DNA, that how old is the particular tissue in the body of the victim. So can you imagine how advanced and how scientific these tests have become just in order to determine age. And under the POCSO, you know that it is so important to determine the age of the victim so as to not only sometimes protect the rights of the accused, but also to bring the accused under the book because of section 29, the presumption of innocence. And in a 2022 judgment of, I think, authored by Justice Pardiwala, it's called Shubham Sankra 2022. I've forgotten the citation. There the Supreme Court also took into account the ways of measuring of age determination under section 94 of the JJ Act, read with section 15 in some circumstances, and saying that visual appearance of a child or visual appearance how a person looks is, cannot be a determinative factor, and it can be full of error, and therefore specialized tests must be developed to determine age. And the last, of course, I'll just one line on that, is the cyber crimes. You know that now children are, the biggest victims of cyber crimes, whether it's child pornography, whether it's morphing the image and using that particular child's face, and it is so quick, it is so heartless, and it does complete and lifelong damage to the child. So I'll forget to just quickly in 1 minute show the slide, so that since I've spent some time on it, so might as well show it. So just the convergence, I've already spoken about these things. That's the JJ Act, the POCSO Act, and the BNSS, and the difference as well as the convergence in these three acts. Then the definition of a child and victim under the legislations. You have the sections under the JJ Act, POCSO, and the BNSS. And I'm quickly going through it, but it's with Mr. Panchakshari, so he can share it with anyone who's interested. It's just 8 slides. Then we have the victim-centric approach in the law, and again under that you have the JJ Act, POCSO, and BNSS, and how is the victim treated under these 3 acts. So I've just tried to also include children with disabilities, which is very important now. because that they should receive special care under every circumstance, and accessible procedures which are available to children with disabilities, and that is covered under the POCSO as well as the BNSS. And then of course you have the victim compensation under the law. I've discussed about it, the BNSS, the POCSO and the JJ Act. The sections, I've just mentioned the sections. For all those of you who are not lawyers, but it's not important to remember the sections, just how the Act deals with these issues. Then, of course, the importance of age of child. I've spoken about this, that why is age so relevant and should be the focal point in POCSO cases. And medical examination. Under Section 27 of the POCSO Act, what are the rights of the victim, what is the procedure to be employed for the medical examination of a child. And role of special courts in POCSO cases, very important. Many of you here have handled these cases, many of my colleagues have. So Section 828 of the POCSO, what does it envisage? I'm just quickly going through. You can have a look at it later. And visual assessment, never enough. It cannot be a complete determination. And reasonable doubt about age of the child, Section 94, it's 94.2. 94.2, 1, 2 and 3. What does it mean if there's a doubt? What can the court do? Are there processes for the court to employ if there is a doubt? And yes, about the wisdom teeth technique and the epigenetic clock, which I just spoke about. And that's, yes, that's State of Jammu and Kashmir versus Shubham Sangra, 2022. That's a Supreme Court decision, Justice Pardiwala sitting with Justice Rastogi. Yes, so that's about it. Thank you, and I'll very happily give the mic to my my specialist panelists who will be giving you the ground level experiences of what they have come across. Thank you.
Dignitaries on the dais, Justice Mosumi Bhattacharya, Srimati Rema Rajeshwara Garu, Sri Pagadala Ashok Garu, dignitaries of the dais, the Honorable Judges of the High Court, District Judges, and judges of all cadres, and police officers of different cadres, the stakeholders of POCSO, my pronouns to one and all. The topic assigned to me for this technical session is age in POCSO cases, the complexities in determination of POCSO cases. Really, at one time, it was very challenging. Of course, still also it's very challenging. It's not only interesting, but also challenging. It was more challenging, and it was an emerging issue while we were the initial judges of POCSO courts. Those were the days when we were the initial judges of POCSO courts after the advent of the Act 2012. But now, there is no res integra. Everything is tailor-made, thanks to the judgments of the Supreme Court from time to time and various high courts. So within the time constraints, I would like to deal with some of the judgments of the Supreme Court and various high courts to make the point so simple. There is nothing to be worried. I make it clear, there is nothing to be worried, and this controversy is set to rest. See friends, age of a child. So we have to see from two different angles. First is age of a child as a victim. Age of a child as a victim. And the second thing is age of a person on the other side, whom you call it as a juvenile within the meaning of the word juvenile under Juvenile Justice Act 2019. And also the other category of a juvenile or CCL who can be treated as an adult for the purpose of trial by Children's Court after the opinion expressed by Juvenile Justice Board within the meaning of section 14(3) read with 15 read with 18(3) of Juvenile Justice Act. So these things you have to pay concentration. The first thing is taking a child as a victim. This is of a victim. And this is the other side. That is, you call it as accused, you call it as juvenile, or the third category as CCL being treated as an adult for the purpose of trial by Children's Court. The special category coming under 14(3) read with 15 read with 18(3) of Juvenile Justice Act 2012. How to resolve it? Second category, this is of a juvenile. And of three categories, I already mentioned three categories. So coming to victim, coming to the accused, coming to child as a victim, the Honorable Justice has just now said, child is defined under the Juvenile Justice Act 2 Clause 1D as a person below the age of 18 years. Below the 18 years. It goes in line with the same definition given for child under the Juvenile Justice Act 2019 and also previous JJ Acts also. Now under the BNSS also, and of course BNS also defined a child. 2 Clause 3, it has also given the same meaning. A person below the age of 18 years is called child. So under 2 Clause 1D of POCSO Act, child is defined as a person below the age of 18 years. Then a controversy arose till 2017, till the advent of a judgment of the Supreme Court. There is a controversy. Which age of the child? Is it biological age, chronological age, physical age, or mental age? A judgment of the Supreme Court by two giants of the Supreme Court, that is ERA through Manjula Kripendor versus State NCT Delhi. 2017-15 SCC, page 133 is the page, you may note. 2017-15 SCC, page 133 is the judgment. 15 SCC, page 133 is the judgment. It is ERA through Manjula Kripendor versus NCT Delhi. Facts of the case, of course, though I am aware of the time, I have to necessarily tell you the gist of the facts. There, ERA, a child, represented by her guardian, mother, Manjula Kripendor. She was of 38 years old. Physically, she was of 38 years old. But she was suffering from cerebral palsy, a disease under which her mental age is not more than 6 to 8 years. That was a controversy. So up to the stage of Delhi High Court, her mother was successful in getting her treated as child within the meaning of Section 2 Clause 1D. But when it came to the Supreme Court, this judgment, the Supreme Court, delivered by two eminent judges of the Supreme Court, Justice Deepak Mishra and Justice F.S. Nariman. Both of them have delivered their independent their judgments of two different judgments, but both of them have given concurrence on the core of the issue. So, Deepak Mishra's judgment, of course, he relied upon the doctrine of casus omissus. Conscious omission. What he opined is, when the legislature has consciously omitted a thing, that should not be supplemented by its courts, unless there are special circumstances to justify the same. The court should not make such an interpretation unless or until they are called for, that is warranted. He opined, because the legislature purposefully omitted it. Mental age, they did not use the word mental. It doesn't apply to the mental age. It's only physical age. When it comes to Nariman, he relied upon the doctrine of Lakshman Rekha. He said the courts have got certain limits. legislature. They should not usurp into the ambit and sphere of the legislature. So both of them have given concurrence on the core point that it is only physical act, a chronological act, biological act, but not mental age. So it is put to rest. There is no controversy now. It's only physical act, physical age. Then another question arose. Immediately another question. How to determine then? Because you know the POCSO Act is complete code. POCSO Act is complete code because it contains the provisions of both substantive law as well as procedure law. If you see the provisions right from chapter 5, they contain both substantive act as well as procedure laws. It's quite independent. The act is quite independent. It's complete code. Then for determination of age of child, there is separate section 34. Section 34. Section 34 says that it is the judge of the POCSO court who has to determine it. Unlike the other courts which may send the record to the Juvenile Justice Board for determination, isn't it? But here it is a complete court. It says that it is a special court that has to determine. That is under 34. Then again arose some controversy. Because first two sentences of the section reads, suppose if you observe first two sentences, section reads that for determination of age of a person who committed the offence, that means CCL, child in conflict with law, first two sentences. So then, does it apply for determination of age of a victim? If you read the section, you will be carried away by first two sentences that is applicable for determination of age of a person who committed the offence. That means you call him a CCL. So does it apply to determination of age of a victim? And then what is the procedure to adopt the inquiry? Is it laid down anywhere? POCSO Act is silent. Rules under the POCSO Act, now recent rules of 2020, they are silent. So where to find? Section reads that same procedure that is applicable under JJ Act, that is applicable. Same procedure that is applicable under JJ Act, that is applicable. Where is that procedure? JJ Act of 2015 now. The procedure on section 94. JJ Act of recent Act of 2015. The procedure is under section 94. When it was JJ Act of 2005, the procedure under Rule 12. When it was JJ Act of 2000, the procedure under section 78. That is clarified by the Supreme Court. I will tell you, I will give you the citation. These two. Previous Act 2005. Where is the procedure? The procedure under Rule 12 of JJ Rules 2007. Then it was POCSO Act of 2000, JJ Act of 2000, the procedure under section 78. This is the same procedure that is now. Then does it apply for determination of age of a victim? There is judgment of Alok Singh's case. The Supreme Court clarified it, Alok Singh. Of course, prior to that, of course, there is judgment of Jarnail Singh's case. Alok Singh's case, there is sufficient. State of Maharashtra versus Alok Singh. State of Maharashtra versus Alok Singh. 2015, 7 SCC, page 772 the citation. 2015, 7 SCC, 772 the citation. You may note down. In fact, of course, I asked them to arrange the same to display, mounted, of course, but they could not find time. Otherwise, I could have displayed. I brought the pen drive also. That's why I'm telling the citations. You may kindly note down. 2015, 7 SCC, page 772 the citation. State of Maharashtra versus Alok Singh. There the Supreme Court, it clarified the same procedure that is applicable for determination of age of a juvenile. Alok Singh, that's the citation. That is also another judgment, madam. General King's case of 2013, this of 2015. 2015, 7 SEC plus 772, madam. There, of course, then the same procedure that is applicable. Then what the procedure then? How to prioritize things? How to determine? Section 94, just now, our Lordship just now said. It is categorized into different priorities. The first priority is to look for the date of birth mentioned in the matriculation certificate or any other academic record. The first priority is to look for any academic record, just like SSC certificate, matriculation or something else. First priority that should be given. 94. First priority is to look for matriculation certificate or any other. Second one is, suppose victim could not produce all these, or guardian could not produce all these things. Then second thing is, any date of birth certificate issued by corporation or municipality. Second priority is, any date of birth certificate issued by a corporation or municipality. Suppose victim is illiterate. Victim could not produce any of these two. Then what is, how to determine? The third category is to go for ossification test, radiological examination, or any other scientific method, scientific new invention. That's just like our Justice Bhattacharya just now said. The scientific inventions, new scientific methods that can be adapted. Ossification test, that is known to us. And second one is radiological examination, that is also known to us. Dental examination, all these things. And any other thing that can be invented in course of time, because we cannot rule out, because till 1953 we were not aware of DNA. Prior to 1953, when DNA was not invented, we were not aware of DNA, but now we are using DNA. That may come. So that's why they mentioned it clearly that any scientific method that is developed from time to time, that can be adapted. Then immediately comes the next question. To whom the error of margin should be given? Suppose you go for radiological examination, go for ossification test or something, some scientific method of determination without going for this certificates, medical education certificate, other certificates issued by corporate, other things. Then to whom the error of margin should be given? There was much confusion, much inconsistency between courts. Some single judges, they held in favor of victim. Some they held in favor of the accused, because some of them developed the view that it is the object of the act. It is designed to give the benefit to the victim, so it should go in favor of the victim. Some said no, it should go in favor of the accused. But luckily for us, there are two judgments. One is of Supreme Court and other is of Delhi High Court reference. They set the controversy to rest. The recent judgment, 2024 SEC Supreme Court, Delhi Online 4484 is the judgment. 2024 SEC Online Delhi page 2284 is the judgment. Court on its own motion versus NCT Delhi. The citation is court on its own motion versus NCT Delhi. Two judges. They elaborately discussed it. They were lucky enough to have the guidance of the Supreme Court. Rajat Mohammad's case. Rajat Mohammed versus State of Himachal Pradesh is the judgment. 2018 9 SEC page 248 is the citation. 2018 9 SEC page 248, they decided. Rajat Mohammad's case. They said that error of margin should be given to the accused because we should not deviate from the fundamental canons of the criminal jurisprudence. They dissolved. So here of the latest reference answered by Delhi High Court, they clarified that the benefit should be given to the accused but not to the victim. So far as the victim is concerned, everything is clear, isn't it? Then coming to the other side of the coin, some controversy here. Recent Qatar's judgment, of course. They have also elaborately discussed all these things. First thing is Siddheswar's case. Siddheswar versus Hasur police station. Siddheswar versus state of Karnataka, of course, and the Hasur police station. The 2016 ILR 4203 is the citation. There, again they made the discussion on 94, and again they made the discussion on Rule 12 under JJ Rules 2007, and again on Section 7A under the JJ 2000. So same thing. Submits how to determine the age of a juvenile, same procedure under Section 94. So a question arose now. Another controversy arose. Suppose in one case, what happened is, it's a very interesting case. There, the victim and victim's guardian, they created some false record. So, education certificate produced by them are the fake records. That was the allegation of the prosecution. But of course, they didn't agree. That means it was tampered record, so as to give the benefit to the victim. Then, you know, under 15.3, that case falling under the 14.3, read with 15, read with 18.3 of Juvenile Justice Act, in between the age of 16 to 18 years. There, of course, you will see 15 says that the determination should be done within 3 months. But here what happened, the prosecution was initiated against these two people. A CC was registered. It may take time. So, is the period of 3 months, is it recommendatory or mandatory? That was the question. Supreme Court clarified. Of course, I will give the citation just now. And they said that let the prosecution be done, but simply because it may result in some time delay, that benefit should not be denied to this juvenile. You may kindly note down this citation. And this is important, that's why I am referring. First thing, Siddheswar, you have noted this. Siddheswar, they have relied upon Shahnawaz case, Supreme Court citation. Shahnawaz versus State of UP, 2011, 13 SCC 751. Karnataka High Court, they relied upon the earlier judgment Supreme Court, that is Shahnawaz versus State of UP, 2011, 13 SCC page 751. This case, please read this judgment. Kulai Ibrahim, Elias Ibrahim versus State Inspector of Police, BI Bazaar Police Station, Coimbatore. 2024, very recent judgment. 2024, 12 SCC page 332. Justice Ranjan P. Desai and Justice Madan Bilokur. Kulai Ibrahim. The difficulty is they could not arrange, sir. Otherwise, they would have shown it. Okay, I will write, sir. Thank you. I will write. This is 2024. 12 SCC 332. Kulai Ibrahim. Kulai Ibrahim, Elias Ibrahim versus Inspector of Police, State through Inspector of Police, BI Bazaar Police Station, Coimbatore. 2 judges of the Supreme Court. Of course, the controversy falling under 14.3, read with 15, read with 18.3 of the JJ Act. Here, of course, there was one difficulty. Friends, I would like to clarify. Recently, of course, I answered some session arranged by Amravati High Court. There I had sufficient time. I could deal with the session 1.5 hours. There I fielded so many questions, but here I am having some restraint. I can't speak more than this. There they raised these points. Where to keep the accused? Suppose POCSO judge is a man who crossed 16 years, 17 years. He is produced with the POCSO judge. Where to keep him? That of course, that 19 and 20 of JJ Act. So to keep people in a place of safety, there the section reads, to keep them in a place of safety. You should not send him to jail. Though it's a children court is nothing but POCSO court. He's not a juvenile. He's declared as an adult who can be tried as who can be tried by the children's court. That's the finding given by the Juvenile Justice Board. You may differ. You may pass an order 19.3. You may differ. You may not agree. Children's court, you may not agree. You will send back to the Juvenile Board. We accepted it, then you have to try him. But where to keep him then? Then place of safety as mentioned section 19 of the Juvenile Justice Act. Suppose he crossed 18 years, can he be sent to the jail? Again section 20 operates. So there are all these, of course, complexities, they appear so ostensibly, they are all put to rest. This is what I want to impress upon. There are judgments, so many judgments. Read them thoroughly. Of course, everything is so simple. There is no controversy now. Thank you, madam. Thank you. Thank you, friends, for listening to me. Thank you.
Thank you very much, Mr. Bhupati, for giving us so many citations and so many cases, decided cases. I'm sure all of you have taken them down, and if you are interested, you can look up the citations with regard to the controversy of age determination, one of the most important topics. So I'm really sorry, Mr. Bhupati, for hurrying you, because we still have two more speakers, and we would love to hear from them, from their own lived experiences. So, can I pass on the mic to Ms. Srimati Rima Rajeshwari, who will give she was a very important addition to our Juvenile Justice Committee and did wonderful work. So, we would love to hear what she has to say. Thank you.
Esteemed officers, Honorable Justice Moshini Bhattacharya, and my fellow panelists, Honorable Retired District and Sessions Judge, my colleague Ashok, and all the distinguished guests, especially justices from the Honorable High Court of Telangana, and all the participants. A very warm welcome and also good afternoon to all of you. We are also partners. We are a very important stakeholder in this 2 days national consultation that is happening with a lot of focus on children and their rights and the wide ambit of crimes being committed against children. Because of lack of time, I'm not really going into all the stories that I brought with me. Very quickly, I'll show the presentation with a focus on what exactly we do at the Women's Safety Wing. I stand here as a representative of the Women's Safety Wing of Telangana Police with the permission of our ADG, Ms. Charu Sinha IPS, who has been a guiding force for us in terms of bringing a lot of focus on this subject. And also I've had the good fortune of being guided by Justice Bhattacharya ma'am and also Justice Nanda ma'am, being a member of the Juvenile Justice Committee for the past 1 year or so. Women's Safety Wing has actually received a lot of guidance from them. We started looking at the issue holistically, which was kind of not there before. For the past 1 year, a lot of important initiatives have been started. And earlier we would only look at case monitoring, we would only look at the different stages of case. especially cases against children. But now, having learned a lot from the Juvenile Justice Committee, now we go into a lot of other aspects also, how these children are being cared for in the institutions in coordination with the WCT department, with great guidance again from Anita Ramachandran ma'am. And the SLSA, Panjakshri Garu, has also been quite supportive in that regard. So it has given us a lot of, opportunities to learn and look at the issue holistically. So before I go into the presentation, very quickly I would like to mention about something, a very important step that was taken by the National Human Rights Commission, and eventually in one of the important judgments of the Honorable Supreme Court of India. If you remember, in October 2023, the National Human Rights Commission took a very important decision. They thought this is time that we should give a very clear and concise guidelines in terms of tackling this issue. We've all heard about child pornography. We've heard a lot about the different kinds of crimes being committed against children, in both physical and also in the digital space. But not much awareness was there among the public. And if you look at the police officers, especially the practitioners within the criminal justice system also, there was no deeper understanding of the issue at hand. So in 2023, I should especially thank David from UNICEF for bringing a lot of focus on this issue and also educating us in the process. So this is a very, very important document for all of us to have. This should be a very this should be an important reference point for all of us to start looking at this issue going forward. So they said that any child, if a child's normal childhood is disrupted by any means, it can be a crime, or it can be an exposed to vulnerability, or it can be an act which is actually infringing upon the normal childhood of a child, it is as good as violation of the basic human rights of that child. And with that, they gave this important document and they told us what exactly we are supposed to do. And eventually, Government of India got into a memorandum of understanding with the NECMEC, the National Center for Missing and Exploited Children. It's actually a non-profit organization based out of United States, and they've done a lot of work in terms of keeping children safe in the digital space, especially the dark web, which we keep reading about in the mainstream media. So after the MOU was signed, we started getting this, the CTR reports, the child, tip line reports, which is being shared with all the state police organizations through the National Crime Records Bureau. So basically the MOU was signed between NECMEC and NCRB. So today in India, every time there is a crime committed against a child online, if it is reported either by the victim herself or himself, or by an interested party, or through a public, a lot of preventive actions are being taken by different police organizations. So if we receive any input regarding a crime being committed against a children in the online space, action is immediately initiated. And earlier, if you look at the timeline that was given to all these intermediaries, all these social media companies, we call them intermediaries, it was almost 36 hours. For example, a child's, compromised pictures are being posted online, and a case is filed, and the law enforcement agency addresses a letter to the intermediary. It can be Instagram, WhatsApp, or Facebook. And if they don't take down the content within 36 hours, they are liable to be punished, or we can initiate action against them. But now the NHRC guidelines clearly says that this 36 hours is like way too long. It should be brought down to 6 hours, because I'm sure you must have, being practitioners of law, many of you must have encountered cases where children actually go through unexplainable suffering whenever such incidents happen. I'm going to go into the details of it. I'll be giving you the various types of criminal activities which are being committed against children online. But it's very difficult to explain the kind of trauma a child goes through once this basic rights or privacy is violated. So with this, I would like to start my presentation. Can we move on to? So see, when we started the technological revolution in the late 90s, and eventually around around 2014 and 15, when we started embracing digital India revolution, we had absolutely no idea about the flip side of the whole thing, right? See, today India rides high on this, honor that, we are probably one of the largest, being the most populous country, we are probably having one of the largest population which is online. And the digital India revolution is being spoken about with a lot of pride and honor. But on the other side, there was this issue which was brewing, and in this internet, which is actually looked at as a positive social force for, for becoming an enabler for growth, becoming a multiplier for growth and development, was also being used, to commit crime against children. I'm not going into the crime against women at all, because today we are only focusing on children, crime against children, and it was leading to significant harm to a very important, target population of our country. So we missed out on that crucial aspect, but better late than never. For the past 6 to 7 years, Government of India and all the state police organizations have done a lot of activities to address the issue holistically. So today, if you look at the percentage of children who are actually online, I mean, this figure is almost 2 years old. I mean, I couldn't have the latest figures. 97% of the children between the age group of 5 to 17 are online, literally all the time. Very recently, I was home. I went to Kerala to see my parents, and we were having a family dinner, and one of my cousin's wife has a 3-year-old, and the child just simply refuses to eat, and she just gives the smartphone and the child starts eating, and the child is not even looking at the mother, neither looking at the father, neither looking at the the grandparents. The child is just literally, the head is just into the device, right? And if you remember, when we were children, when we were growing up, if you don't eat, what the mother or the grandmother used to say, what did they say? They would just say that khao nahi to police aa jayega, right? But I mean, I think we really have come a long way. We really have come long way, that the child is it was a slap, yes, same, ma'am. But the add-on was the fear of police. So, but things have, we've come a long way, where the child is totally oblivious to what is happening in the surrounding. There is no social interaction, the character formation and the character building is not happening properly, and the parents, being busy, most of them are career professionals, and they live in nuclear families, there is no social support, they just totally leave the responsibility to the mobile phones. And there's a lot of lack of understanding. There's a huge, the issue of ignorance among the parents and also among the teachers about this potential risk which are awaiting these children in the online space. So as per one of the reports published by NECMEC, because every year they come up with this report was accessed for the year 2022 and 23. 22% jump was there in crimes committed against children online, and unofficially I tried to collect some data, and this figure is almost going to be 40-45 for this year. So it is a big number. So very quickly I'll tell you about some of the types of cases that we encounter, we come across as part of as part of the She Cyber Lab that we run as one of the modules in Women's Safety Wing. Cyber grooming. You see, this is a very important issue. This is a reflection of what is happening in today's society, right? So back in those days, who used to groom a child? It's either an uncle or grandparents or the peer group, some friends or some people, the neighbors, or some people in the locality. Today this whole grooming process happens online. Every child is active in at least more than 2 social media platforms, and today's kids are this is an Insta generation, right? They're all they call it gram, Instagram, the Gen Z calls it gram. They are a gram generation. Their interaction, their social interaction happens more online than in the physical space, right? I think the very limited the time interval where they actually talk to fellow human beings is when they are actually in school, or if they are into some sports activities or some extracurricular activities. All other times they are actually into the they are hooked onto the mobile phones. So cyber grooming happens when somebody befriends a child with an intention to commit sexual abuse against this child victim in the future. The second type of crime that we have encountered is cyber stalking. This is really widespread. If you must have read a lot about the she teams that we have in the state of Telangana. It's one of our flagship initiatives, and Telangana police received a lot of praise across the country for this particular initiative called she teams. So in 2014-15, when we started she teams, we were only handling issues of eve teasing, crimes committed against women in the public space. The goal was to keep the women and children safe in the public spaces, right? But today, when we look at the kind of complaints which are being received by these she teams, most of them have something to do with online space, and most of these complaints are received from young adolescent age group, especially girls studying in like 9th or 10th or inter first, second, or in junior colleges. And the kind of, if you look at the number of complaints which are being received, and mind you, this is only I'm only talking about the number of cases which are actually coming to the notice of the police. And what happens in a society like ours, even today, in spite of all the strides that we have made, all the development and the progress, even today going to a police station is a stigma. Okay, it's not really a socially acceptable thing to go and report something to the police station, at least in the rural areas, right? So we are looking at something which is actually really big, and through a wider community outreach, we really have to address this issue and educate the parents and the teachers, especially the teacher community, about these issues. Cyberbullying. Earlier, we would receive complaints that, a boy approached me. He wanted he wanted me to be in love with him and like marry him, but I refused, and he's not letting me go. He's like following me wherever I go. But today, this is happening online, right? Earlier, if you just say no to a boy, refuses to meet him, then it just stops then and there. You can take adequate precautions not to be in the same place where the boy is. But today, when you're online, when you have WhatsApp, when you have Instagram and Facebook, it is literally difficult. It's becoming quite hard for these, young age group to stay away from these, perpetrators. We receive complaints of, girls getting abused, and I have gone through that language. It is extremely abusive. So the kind of mental trauma these children go through, it is quite easy for us to book a case and take up investigation and probably initiate legal action against the person. What about the mental trauma the child goes through, the girl goes through? And sometimes when parents come to know about these issues, the girl child is not allowed to continue the education. So we are actually looking at a bigger social issue. Sextortion, this just does not stop with children. Today this issue is quite widespread. I have received complaints from even educated people, a lot of senior officers, many acclaimed professionals in the society, that you are busy. We are always busy. You have the phone in the hand, and sometimes you get a call. Sometimes it's a video call. Without realizing that it's a video call, you're just taking the call. You are attending the call, and on the other side of the window, there is a woman, absolutely without clothes, right? And the screenshot is taken, and that screenshot is used for blackmailing. And a lot of such cases are happening irrespective of the widespread awareness programs which are taken up by the police. Phishing, it's very common, not exactly a sexual offense, but it is quite common. A lot of people have lost a lot of money, and especially children, because these days, parents started giving pocket money to children as young as like 10, 11, 12. And they are also subjected, they are also vulnerable to these kind of scams. Where somebody, I was just leaving home after lunch for this session. It's quite funny, because today I was supposed to talk about cybercrime. When I just started, I was repeatedly getting a call, because we were working on multiple issues. Without realizing, I just took the call, and the person said, there's a courier that came for you from the bank. I'm going to SMS one number to you. Please call that number and talk to that boy. I said, okay. I didn't understand. I didn't realize that it's a scam call. And then the person called me like 5 times. Then I had suspicion, and then I sent the number to my cybercrime team, to Sub Inspector Harish, and he checked, and then the person was trying to hack into my WhatsApp. And for 2 minutes I was a little like, imagine if your WhatsApp is hacked. It's very, you can reverse the whole thing, but it's a hardship that one has to go through. So you have to be very careful. We feel that with smartphone life has become easy. Actually, it has not, and it's our responsibility to teach the children as well. Cyber defamation. A boy and girl, they meet, they fall in love, they are in a relationship, they break up, and then the whole dirty linen is washed in the social media platforms. Pictures are being posted, privacy is compromised, and a lot of abusive language being used against the children. Especially from, we have encountered so many such cases in schools in Hyderabad where the parents come and show us screenshots about this abusive language which is being targeted, against these children. CSAM. I'm going to talk in detail about this after the presentation is over. But ma'am also is taking a lot of, initiative in terms of creating awareness about this issue. As on date in India, child sexual abuse material is one of the most important challenges being faced by us, right? One, because of lack of awareness among a lot of us. And two, we don't have the right kind of resources and the adequate manpower to handle this issue. Earlier we used to use this terminology child pornography, but later on there was an amendment done to the act, and now we say child sexual abuse material. So NECMEC, in collaboration with the NCRB, is taking up a lot of awareness activities. I foresee the coordination center at the center, Cybercrime Coordination Center. They also run a lot of courses. They run public awareness initiatives online. They try to reach out to different sections of the society. But it's like a small grain in the sand. So there's a lot to be done in this area as well. So what is the MO used by these, cybercrime offenders? Trust building, just like how it happens in the physical space. A lot of these children don't have the social abilities to form relationships in the physical space. If you look at today's kids, earlier, a kid would have like 5 to 6 friends. And today also they have 5 to 6 friends, but they are not like, meeting in person. It's all online. It's all on chats. It's all like snaps. It's all on like sharing Instagram reels. How does a Gen Z, communicates with other kid? With the peers, they're all sharing reels. And whose reel is it? How exposed they are, how vulnerable they are in this space, they are not aware about all these things. Social engineering is when a potential victim is under the control of the perpetrator, this whole brainwashing that happens. And eventually the victim is subjected to all kinds of, abuse online. And then if the person tries to establish a communication with the victim, then, it leads to a bigger crime. Platform exploitation. These days, most of the kids are heavily into video games. And most of the video games have this option of in-app or the in-games, chat box. So that is also used sometimes for anonymity. These perpetrators are opting for these, in-game chat box, rather than the regular social media, chats. Grooming, there is a pattern to it. First they establish contact, then they just normalize this communication contact, and then the victim is slowly isolated because the victim is like heavily onto the person who is actually grooming, and she or he stops interacting with the rest of the family members or the friends. Then the actual exploitation happens, and by the time the issue or the crime happens, it's too late. Low self-esteem, we will talk, because of lack of time I'm not going into the PTSD issues of it, but very quickly you can take a look. What is the impact these crimes have on these young, on these young children? There's a psychological trauma, they are socially isolated, and obviously there is a severe decline in their academic performance, and most of them start self-harming. And these days it's really difficult to say anything to the children, right? 10th class mein marks kam aaye, parents are scolding the kid, and the kid goes and commits suicide, right? It's very fragile. In fact, our boss, ADG Charu ma'am, has conducted a lot of training sessions in this regard for the police officers about how to look at this aspect which is actually overlooked in the due course of our work. Then obviously there is long-term consequences. We are talking about a future generation. If this generation is lost, obviously the future is lost. And quickly about the initiatives that we do at Women's Safety Wing. She Cyber Lab, it's a matter of pride for us. Started as a very small group of team. It is handled by Sub-Inspector Harish, very talented young constables such as Arun, and couple of others. And they do an amazing work. It is a preventive initiative that we have started in the Women's Safety Wing. Using the open source investigation tools, these young police officers, they train themselves first, they educate themselves first, and they do something called the cyber patrolling in the suspicious platforms and also in the dark web. So whenever we come across profiles or activities, so especially from repeat offenders, their profiling is done and we generate something called an intelligence report. And then the ADG Women's Safety Wing addresses a letter to the chiefs of the police force in all the states where the presence of the accused is established. And so far we have generated 64 such intelligence reports. This year we have addressed letters to the DGPs of like 14 states, and very recently there was a very interesting case also. I will go into the case studies also. So this is like it's a preventive policing activity that we've been doing. Cyber Congress, this was our very first campaign where we trained all the students about cyber safety, followed by Her campaign, where the cyber safety campaign focused a lot on girl children. We covered almost 3.75 lakh students since 2021. It was implemented in 3 phases with an amazing support from WCD department and also Department of Education in state of Telangana. Cyber Ambassador program, which is currently ongoing, we wanted to look at the target group studying in government institutions, especially in hostels, the welfare residential schools, and we covered almost 7,350 students and almost 4,000 teachers and 2,000 government schools were covered, and we imparted extremely professionally made content were made available to this target group, and digital safety education was imparted to them. And as you all know, in 2024, Telangana was the first state to have an exclusive bureau for cyber security. And our awareness programs, we continue to do them. Few case studies for you to understand like what kind of cases are reported. WhatsApp calls, 2 minutes on WhatsApp calls scam alert. This was exactly what I just faced in the afternoon. So somebody will call and they will say that I'm going to send you a number, please call that number, and then a courier is awaiting you or a parcel is awaiting you. So in this, if you look at this number, there is asterisk 401 asterisk, right? This is actually a call forward option given by Airtel, the internet service provider. So somebody calls this victim and they say that we are sending a number, please add this prefix and call that number. The person gets access to the WhatsApp, hacks into it and uses this WhatsApp number to register to commit crime, and also has access into all the private messages of the victim. And the next case is about this is the Telegram big bus that I was talking about. So She Cyber Lab, which is actually doing the cyber patrolling, came across the profile of a suspicious person who was actually handling a huge volume of child sexual abuse material. So we did a lot of investigation, back-end investigation was done. Based on the investigative findings, we generated the intelligence report and it was sent to DGP West Bengal, and there was a very prompt and quick response from West Bengal police, and the person was arrested. When he was arrested, he had just one device, and by then he had almost like 1,000 different child sexual abuse material. How does he get so many pictures of these young boys and girls? It's all from the open social media platforms. So when your kid is posting her picture or his picture, it is just available for everybody to see. Instagram harassment, this is again a very interesting case where a father approached and they said that my girl's Instagram account was hacked and they are just posting very abusive content. So our team started the investigation, and eventually we found out that the whole thing was stage managed by the victim herself, so that she can post the story online and gain more followers. So the children are actually living in this this fake virtual world. They are totally cut off from the realities of the world. So in order to, she even went to the extent of dragging the whole family to the police station, and she started writing graffiti on the walls of the bathroom. She started posting all these abusive content herself, just to create that sensationalism, so that she will have more followers when there is a new account. SMS bombing case, again this is a case where your number must be used by an accused to commit cybercrime elsewhere, and you wouldn't even come to know about it. till the time somebody goes and reports. So this was a case where a girl, reported about receiving warning messages, and we started investigation. And when we traced the person, this was a Marathi-speaking person sitting in Maharashtra, and he had absolutely no idea that his number was being used. His cousin uses his number, hacks into this number, uses this number to register himself on almost 36 social media platforms, and creates a way into WhatsApp, hacks WhatsApp, and starts committing crime. So that is why whenever you use an app, please start using the two-factor verification in your phones. So these are like some of the technical, the digital defenses that the children can be taught by the parents. Most important, parental controls. Almost every platform offers this. The network level filters are already inbuilt, and every time a device is given to the child, parent has to ensure that parental controls are activated. Privacy settings, obviously, you should teach children, how to set up the private mode in all these apps, and virtual private networks. VPN is legally allowed in India now, so we can teach children to have VPN enabled devices. Last but not the least, very important, how to report. Most of the time, these people go scot-free because we don't report. We feel that, acha theek hai, this is something small. Why go to the trouble of reporting and, doing rounds in the police station? We just simply don't report. Because of that, internet is becoming a breeding ground for all these perpetrators against the children. So these are the different ways we can report the crimes. Thank you so much.
Thank you, Ms. Rima Rajeshwari, for actually educating us on all the words, the terminology, which most of us may have been aware of, but what exactly it is and how it is relevant for our daily lives, we needed to know. And before I hand over the mic to Sri P. Ashok, who will give us a comprehensive overview of the 3 acts, 3 legislations, I just want to add one line that, we tend to see children as victims. But now the time has come, or maybe for some time now, children are also consumers. Children are also consumers of this kind of content on social media, in the dark web. And I remember, when we were children and when our parents gave us some money, whether it was 10 rupees, 20 rupees, our first thing was to go and buy a chocolate or something to eat. And now I read a survey somewhere, maybe last year, that now if a child, and particularly you'll be shocked to know in the rural areas, and in the semi-rural areas, semi-urban areas, if they get 50 rupees or even 30 rupees, they will go to their local pan shop and they will give that money and they will watch pornography for 5 minutes, 10 minutes, depending on how much money they have at their disposal. So can you see, our entire notion of entertainment, our entire notion of pleasure has changed over the years. It's now no longer restricted to a chocolate or something, or a mithai or a samosa, but it's to watch pornography on the web. So children as consumers is something we really need to worry about. And thank you, Ms. Rajeshwari. We are all so engaged with our WhatsApp accounts, whether calls, whether images, whether videos. So next time you get a call from an unknown number and you get repeated calls or you get a video call, we know what to do. So thank you for that. And over to you, Ms. Sri P. Ashok. Thank you.
ఇది కాదు నో నాట్ దిస్ రిపీట్ ఇది కాదు రిపీట్ చేయాలి ఒకసారి రిపీట్
షేర్ చేస్తాను. Honorable Justice Bhattacharya ji, Chair of the today's panel discussion, Bhupati sir, Madam Remaraleshwar garu, Justice of High Court, other dignitaries, all stakeholders assembled today. Actually, I am going to deal on subject of comparison of POCSO, JJ, then BNSS, etc. Before I just wanted to, before I go to my slides, I wanted to emphasize the importance of the POCSO, importance of the JJ, the almost decade plus old act, the crime committed against the children, and the comparison, the study conducted to analyze the crime against the children. It was very, this thing, 30% children below are the, 30% are the children in India. 96% children, the crime committed were the known persons against the children. 96% children are girl child, and 25% are crime committed are the sexual assault cases. 18% are sexual harassment cases, and 56% cases are the age of the accused when compared was age between 21 to 30 years, and in 36% case only the scientific evidence was used. In the morning session, Honorable Justice has been emphasized on the scientific evidence, and also there are 56% cases where the offences committed in the POCSO are penetrative and aggravated penetrative sexual assaults. So other problems just now Bhupati sir has emphasized on the age determinations. Madam Bhattacharya Madam also brought out latest technologies on the age determination and all. But the issue is when the age, in the age determination, when the people are, children are focused for the radiation, there is also a problem of this thing. So I now focus on the issues which I have given topic. Before commencing, I always quote this statement of our Justice Madan B. Lokur, who is pioneer in the child protection. A child victim is not a statistical number. We are talking of a life that is going to be there for many years. We all, the stakeholders, which we are aware of that. This is because it's a big mandate why we are here. We have the constitutional mandate, we have the ratified the UN Convention on the Child Rights, Article 415, 16, 23 and 39 emphasizes on the child protection and child laws. This a small comparison I made between the laws. The definition was given in the definition law. In juvenile justice it is below 18 years, under 2, section 2 and 12. Then in POCSO also it is 18 years under section 2D. Child means any person below the age of 18 years, and it's a gender neutral law, you all know. In Bharatiya Nyaya child means any person below the age of 18 years. And key protections provided under the laws. In juvenile justice, the rehabilitation was the important aspects. Care, adoption, trial by the juvenile justice boards, and the importance of the child welfare committees, child welfare police officers, then probation officers, district child protection units, the special juvenile police units established under section 107 of the Juvenile Justice Act, the composition of the SJPU, and under POCSO similar provisions are set up as there. That is, child welfare committee is one of the key areas where the child of the sexual abuse has to produce before the CWC. And SJPU has a pivotal role because under section 19 it is the duty of the SJPU or the local police to report the offence of the sexual abuse. The District Legal Services Authority is also an important organization because the compensation, distribution and other aspects to be taken care. The shelter is another important aspect where the victims of sexual abuse have to be produced in the shelter homes or the CCI units. Then rehabilitation, many of the sexual abuse victims in our experience, we have seen that many of the children who are sexually abused are losing their education. So such people have to be provided the rehabilitation for their further education, and in some cases children who are working are also losing their jobs. So for such people we have to provide the rehabilitation processes. Then MPTs was one of the important and major challenges in today POCSO cases, because we have the time as per the Medical Termination of Pregnancy Act for only 24 weeks. In recent judgment, one of the cases, the Honorable Supreme Court has reminded back the Honorable High Court of Mumbai, wherein a delay has been caused in conducting medical examination, whereby the parents have changed their version and they wanted to keep the pregnancy without the termination. So another important aspects on POCSO is there in the provisions is that support persons. Thanks to the Women Safety Wing for providing the Bharosa centers, where the support services persons have been provided, which was mandated under Rule 4 of the POCSO rules. Then we have interpreter, translators, experts, special educators. All these services need to be utilized either by the police when interacting with the children, or the special judge when conducting trial. Then we have offences against children and punishments are also there. So offences under Juvenile Justice Act are punishment for cruelty, unemployment, begging, intoxication, liquor, drugs, vending, peddling, sale of children, corporal punishments like that, kidnapping, etc., which were marked in the Act, we mentioned in the Act from 74 to 89. And in the POCSO Act, before the POCSO Act, we do not have the definitions for sexual assault, sexual harassment, pornography. These sections were brought in as per the POCSO Act. So, and also penetrative sexual assault, aggravated penetrative assaults. All these sections will deal for the victims. Say the punishment is ranging from 3 years to the life, that is remainder of natural life, and also in some cases it is death also. In one of the cases where I was in the field as Additional SP Sangareddy District, we requested to the Honorable High Court for a speedy trial in one of the victims of 6 years old. She was raped and brutally killed. In that case, the Honorable Special Judge of Sangareddy has given judgment within a span of 6 months, and in that case the offender was given punishment of death penalty and also compensation for about 10 lakhs rupees to the next kith of the victim. Though incorporated the POCSO provisions only, Bharatiya Nyaya Sanhita, we have the 63, 65, 64 like that, and in Bharatiya Nyaya Suraksha Sanhita we have to safeguard the procedural, trial and examination of the witnesses. When we are examining the witnesses under 180 BNSs and also under 183 BNSs by honorable magistrates, the care should be taken while interacting with the children. The sensitivity has to be involved when interacting with the children. Trial of the juvenile offenders. In juvenile justice boards to conduct the trial as per section 4 of the juvenile justice board. Child friendly court setup is already there. The preliminary assessment into heinous offences is one of the important area where many of our juvenile justice officers or the police officers, they are not utilizing this opportunity in producing the matter before the JJB to escalate the matter to the children court. Then in POCSO also we have special court orders are there. Special courts are established, special courts are in place, and judgments have been rendered as per timely. The beauty of the POCSO Act as per my knowledge is completely it's a procedural law, completely it is saying you have to do this, completely saying you have to give this compensation, completely directing us you do this punishment and like that. So in Bharatiya Nyaya Sanhita, trial as per the seriousness of the children, here the heinous offence, that is between 16 and 18 age, this was added in the section 15 was added in our Juvenile Justice Care and Protection Act 2012, owing to the recommendations of the Justice Verma Commission after the incident of that Nirbhaya incident. So guidelines are there under the Bharatiya Nyaya Sanhita, Naya Suraksha Sanhita. The trial, in camera trials, fast tracking of courts, etc. has to be made done. So police involvement is very, very important under all these acts. Especially he is the first responder and his ability to extract the truth is very important. So we have the setup of juvenile justice, special juvenile police units. Child welfare police officers are also placed in each police station as per GOMS number 25. And special juvenile police units also established in each district, headed by additional deputy commissioner of police to deal with the children of sexual abuse and also the juvenile child in conflict with law. There is, we all know this important aspect of this mandatory reporting provision under Juvenile Justice Act as per section 19, and anybody who come across any incident of such nature of having offence against the child must be reported to the local police, that is special juvenile police units. Otherwise, it's a punishable offence under the same law. And one of the, when I am interacting with the CWCs of in a session, one of the CWCs has informed me that despite of several complaints, in one of the district the case was not registered. Immediately I talked to that concerned officer, then the FIR was registered. Here all the stakeholders is very imperative, especially doctors who doesn't report the matter. In MPT cases, they just do the MPTC and then leave the victim. So this is an offence, and then all the person who got the knowledge will be punished. Then police to follow in the juvenile POCSO Act, statement recorded to be child sensitive, as I told you, and in the language spoken by the child. Consent and reporting is mandatory, reporting is there under POCSO, and protective custody and observations. In all juvenile justice cases, the observation homes, place of safety for juveniles to be provided, and special homes. These homes are run by the government, and in some cases it is by the NGOs. So victim has to be, even the juvenile person in child in conflict with law is also to be treated as a most important person. Victims kept safety during trial if needed. During the trial, if the victim of POCSO faces any fear of this thing, then she can be conducted in the, kept in the shelter homes. Then victim compensations has been provided. Madam, Justice Madam has been emphasized on this as per our 357 ACRPC with the provisions. And the NALSA fund is there, special, then also SALSA. Then DLSA is responsible for the disbursement of the fund. Compensation fund is available, state victim compensation fund is available. And then BNSS mandates victim-centric files allow compensation claims. Compensation in one of the judgment, Bijoy versus West Bengal court, the court has also emphasized to give more compensation other than the regular required compensation, since the state has the responsibility to protect the children and failed in its activity. So in-camera trials, most specified, mandatory in-camera trials are there. Mandatory in-camera trials to be conducted, which is already in place. So especially establishment of our court in Hyderabad city is one of the greatest court for the child specific this thing. Then speedy trials, Juvenile Justice Board to conduct a trial in 4 months. But child friendly and fast track courts, as per the POCSO Act, the judgment shall be completed after taking the cognizance in 1 year. So time bound investigation for the police officer in 60 days, and this is also being seriously monitored by all the child sexual abuse cases and also rape cases by the Government of India Ministry of Home Affairs. So non-disclosure is one of the important provisions available under the Juvenile Justice Act for 74 and also section 23 of the POCSO Act. Then disclosure also is an offence under BNS 72. Presumption clause is there. This section presumption clause, that is age, has been much talked on this by Sir Bhupati sir. There is abatement clause under POCSO. Whoever abates, then the punishment is there under 17. The presumption is very, very important clause. This the accused has to prove his guilt. Then public awareness is one of the important arena in which all stakeholders have the responsibility to conduct public awareness about the POCSO Act and JJ Act and the offences committed. In this aspect, the Bharosa centers are doing a lot of work by analyzing the hotspot analysis and then conducting awareness campaigns. This is some just words that we have to conduct copies to the victims. No face-to-face meeting of the child accused, and no to keep the children in the police station beyond sunrise and sunset. No publishing of material. Safe corners. In recent times, we have opened many safe corners in the police stations for dealing with the POCSO as well as the juvenile cases. There is beautiful institutional mechanism as established to provisions have been provided in Telangana. One is that Bharosa, you all know that Bharosa officers are also is there. A single window system, support primarily towards quest for justice delivery and rehabilitation. It's a 24 hours running organization, and video conferencing facility is also there. In some of the cases, honorable magistrates have conducted video conferences. Recording 161 statements by the police officer. In all Bharosa Center, one sub-inspector of police has been provided. One of its kind child-friendly court was established in Hyderabad city. It's a paperless center administered by the Bharosa Society, headed by the Women Safety Wing Additional DGP Madam. And child rape and child sexual abuse cases have been taken. Initially, it was opened in 2006 with one center, but in 2021, it was started in a massive way. By now, we have created about 29 centers across the Telangana state, each district having one Bharosa center, and in tri-commissioners, we are going to have 2-3 centers in each district. Thereby, we are, going up to 35 centers. Immediately, as soon as the victim comes to the police station, she will be immediately sent with a requisition to the Bharosa Society, where the Bharosa people will go, and then victim will be examined by the psychological person, who is psychologist is already recruited there, and she will examine the victim, and thereafter, after talking to her, after conducting an interview, then she will put to before the police officer for recording the statement under 24 of the POCSO Act, and then medical examination also conducted in Hyderabad city. We have the facility. In some other district center we do not have, and that if that facility has been provided, the long waiting of the victim at the hospital will be avoided. Then we have the legal facilities. The legal support person is provided for handling the victim and their legal rights, and also accompanying the victim for recording 164 statement at the court, magistrate court. Rehabilitation center rehabilitation has been provided. Shelter is being provided by producing before the CWC. We will outreach to generate awareness. And the beauty of the Bharosa Society and Bharosa Center is we have provided the victim compensation fund about ₹1 lakh in the each Bharosa Center to meet the immediate medical expenses of the victims of the sexual abuse. And this is a feather in our cap that the Honorable Supreme Court in POCSO versus Union of India has categorically stated to provide one-stop centers, and one such center which is already been set up is Hyderabad Bharosa. This can be used as a model for another one-stop centers in the country. So we have also provided the institutional mechanism provisions. Is child-friendly corners have been created. 10 centers have been created in Sangareddy, and already in operational. With the help of UNICEF, we have taken the assistance from the UNICEF also in providing these centers, where the victims of juvenile children or child in conflict with will be provided, and also we are using these centers for the victims of sexual abuse. Infrastructure in place. These are the places we have already created.